John, give me the high sign. That's okay.
So I think
We're good? Okay. Good morning, everybody.
Good morning, Mr. Chairman.
I want to welcome everybody to our September meeting and welcome our commissioners who are here present in Albany and those who are Skyping in from New York and elsewhere. I also want to begin by welcoming Judge Renee Roth, who has had a distinguished career as a jurist, and we are very happy to have her as our newest commissioner on Jacob. Welcome, Judge Roth.
Thank you.
I think on behalf of the commission, we all look very forward to working with you.
I hope I won't disappoint.
I don't think you will. In any event, let us turn to our first order of business, which is the approval of minutes for our public session for our meeting of July 30th. I think, Monica Stan, we have a slight change that we need to make to those minutes. Is that right?
Yes.
Okay, can you tell us what that is, please?
Sure. On the public session minutes, Commissioner Mitra Hormozy is indicated as absent. She was actually present until the vote on the source of funding regulations. And so I would like to change the first page of the regulations, the minutes, to indicate she was present. And then on page 6 of the minutes, at the end of the discussion, I would like to add that Commissioner Hormozy was not present for the remainder of the meeting.
Okay. Subject to the change that Monica just mentioned, do we have a motion on our minutes?
So moved.
A second.
Second.
All in favor, please say aye.
Aye.
Aye. Any opposed? No one's opposed. The minutes are adopted. Thank you. I'd like now to turn to an update from our staff. Monica, would you turn to the first issue and give us an update on our periodic roundtable discussions with the regulated community, please?
Of course. I just wanted to indicate that we're continuing with this program. We did not have any discussions over the summer, but we are planning to hold a roundtable discussion in October, and we will announce that very soon. So look for an e-blast and announcement on our website if you're interested in participating. Should I just continue?
Yes, please.
Okay, so I'll turn to the next item, which is an update on the annual financial disclosure statements, and that is to just let everyone know that we are working on the academic filings for the financial disclosure statements, which are due on November 15th. As you know, state officers, employees, and legislative officers and employees file on May 15th, but the academic filers file on November 15th. And so we are in the process of identifying who needs to file and notifying those filers. This will be happening over the next couple of weeks, and then we'll get those filings on November 15th, as expected, and we'll continue to report on that. The next item on the agenda, I'm sorry, I went out of order, is an update on the training program. And to that end, the Education Resource Group is continuing to work on the comprehensive ethics training for all FDS filers, and that program has been underway all this year. They recently announced additional dates for the comprehensive ethics training on October 8th, November 14th, and December 11th. These sessions are open to the FDS filers who still need to complete their mandatory training, as well as new hires who are subject to the filing requirement. And the instructions for how to register for those filings are on our website. In addition, we sent out an e-blast to the regulated community so that they were aware of those trainings. We hold those in Albany, but we can make arrangements to do video conferencing to our other locations, in our Buffalo and our New York City offices. Again, if you're interested in attending, you should contact our Education Resource Group. And the staff is continuing to develop online programming through the state learning management system, and we hope to be able to roll out those programs early next year.
Okay, thank you.
And the last item for our staff update is the update on the lobby data. As we previously announced, we've made available on our website a downloadable spreadsheet of 6 years of lobbying data. We anticipate that we will be updating that spreadsheet very soon, possibly next week, with the data from the first half of this year. Again, it's a new downloadable spreadsheet that has the comprehensive lobbying data, and we anticipate that should be available very soon.
Okay, thank you. Let's now turn to item 4 and talk about regulations. Can you, Monica, give us an update on the first item, pending regs?
Sure. First, as the Commission has previously approved approved proposed regulations relating to gifts, honoraria, and related items. Those 4 sets of regulations were published in the State Register in August. The public comment period, which is a 45-day comment period, is ongoing. It will end on September 28th. I believe that's a Sunday, so I think it carries to the following Monday. And then we will be reviewing those comments, continuing to have discussions, and we will represent those regulations to the Commission shortly thereafter. In addition, the staff is continuing to work on the drafts of the public service announcement regulations, which have not been voted on yet by the Commission. And we hope to be able to finalize those and present those to the Commission very soon. But we're continuing to have discussions with the regulated community and develop those draft regulations.
And then after those regs are proposed to the Commission, and if there's Commission action on them, is that when the SAPA process would begin?
Exactly. So far our process has been informal. We've posted them on our website. We've had conversations. We've gotten some comments. And then we will propose them for a vote. And if the Commission adopts them, then they will go through the SAPA process and be published for another round of formal public comment here.
Okay. All right, let's turn to the second bullet point under regulations, proposed regulations. So before I ask Monica to explain what's before you, following our last public meeting, we, as a Commission, I think have given a fair amount of thought to issues that a number of commissioners raised at the last meeting about our source of funding regulations, and particularly the process and standard for considering exemptions to those requirements. And as a result of those conversations, the staff has prepared and circulated to the Commission a draft of a new regulation for the source of funding, which is being proposed to you for consideration and adoption on an emergency basis. There is, calling your attention to the draft that's in front of you, you'll see that on page 9, under 938.8, confidentiality of exemption-related materials, that the proposal for the new reg would be to strike the confidentiality requirement, which would mean that we would consider applications for exemptions to the source of funding disclosure requirements in our open public session. In addition to that, while it's not reflected here, I don't know if there were other issues that people were considering, including changes possibly to section 938.4, which is the standard for reviewing an application for exemption, where the current standard in the reg is a showing of a reasonable probability of harm, etc., and whether or not there would be a change to a substantial likelihood of harm, which is what is actually in the statute. So I believe, Monica, that captures the substance of the changes, at least that we have talked about, and I open it up for discussion before a vote.
Do we have the new 938.9 paragraph?
The 938.8, the 938.8,
paragraph.
The suggestion, and Rob Cohen can speak to this as well, was that we just delete the provision, that the cleanest thing to do is to delete the provision that made it confidential.
So everything then would just be released?
That would be the proposal, is that the application and the discussion could then be public. There have been discussions about whether or not that we should do this in a different way, and sure, if you'd like to address that.
Sure. I mean, I think, look, presumptively, these should be a matter of public record, and I think that's what Commissioner Renzi raised last time. There has to be, though, I think, some exception made. For instance, I raised the example of there's a threat where there's an ongoing federal investigation about the threat, or there really is some substantial likelihood of someone being injured. I think that we have to be able to carve out some ability to at least consider that as a commission before that matter becomes one of public record. One of the suggestions, I think, that came from the staff was a regulation that would essentially make it public unless it's related to an ongoing investigation by a government body or when there are some other extraordinary circumstances, including perhaps an unwarranted invasion of personal privacy. Now, one of the concerns we'll have, obviously, is we don't want an exception that swallows the rule. On the other hand, I think we want to create the ability of people to be able to provide information to us without being concerned that they're going to be threatened, or certainly that a government body is investigating a matter. So I know that the staff has come up with some suggested language, and perhaps we can consider that, if people agree.
well, I have a question, which is, would a simple, if the applicant simply redacted that information, as opposed to submitting an application, or we could direct the applicant to redact information.
Well, if they redact it, then how do we know it's true?
Well, I think there's another.
don't know
There's another issue here, which is that obviously any exemptions that any group applies for, I think it goes without saying that the commission will vet those and consider the credibility, and those that aren't adequately or sufficiently documented to demonstrate the exemption. That's obviously a factor I would imagine the commission would consider.
I don't know, Dan, I think it's a backwards approach. I think we should get everything, and then we should redact it as any other governmental entity might do.
Oh, I agree with you. I couldn't agree with you more. I didn't mean to suggest that we should leave it to somebody else to redact the information. I think the policy here favors full disclosure, and that's why we're having this discussion. Absolutely.
There's two questions, I think, on the table. One is the substantive question of should people be entitled to an exemption under a narrow set of circumstances of the confidentiality, and what are those circumstances? And the second one is, if that's true, then how do we go about doing it? Which is to say, does it come to the commission first to consider confidentially, and then we vet it and decide whether or not it's credible and whether it should be released to the public? Or do we go back to the person and say, we're not going to rely upon the information you've provided to us because we don't believe it should be kept confidential? If you think you want to rely upon this, we're going to release it to the public. Those are some of the issues, I think, that come up.
I think these are valid concerns. I think that, I'd be interested to hear what other commissioners think. I agree with Ellen that the exception shouldn't swallow the rule here. And that whatever we do, has to balance, but there has to be, you have to tilt in favor of disclosure and public disclosure.
I know there was some discussion briefly with Rob this morning. They did a draft template real quickly. That seemed to cover a lot of the issues. One thing I think we ought to be talking about in conjunction with it is what you brought up, Chairman, is 938.4. The statute, I think, indicated substantial likelihood that we've been going on a standard of reasonable. And so I don't think statutorily we have authority to just change that on our own. I believe we need to be guided by the statute on that issue. And I don't know what other people
And
think.
so just to flesh that out, Commissioner Renzi, are you suggesting that we also need to amend 938.4 so that that language of reasonable probability is struck, and we substitute the language that's in the statute, substantial likelihood of harm? Is that what you're...
Yes.
Yeah,
Thank
okay.
you.
And in that area, does anyone else feel that it would be unfair to continue to consider the applications as submitted when there was one standard, and now we may be raising that standard? Should they be given an opportunity to resubmit?
Yes, I mean, I was going to get to that. I think that, and I'd like to hear the staff on this, but I believe the staff has looked into the issue of whether or not the pending applications can be considered if we adopt a new standard. And if the answer is yes, obviously, we're putting those applicants on notice today that if the Commission adopts the new standard, that is to say, substantial likelihood of harm, and we agree that these applications can be considered in the public exception with whatever qualifications we make about the issues that Commissioner Yaroshevsky has raised, that at our next meeting we will take those applications up, and if those organizations that have pending applications in front of us wish to resubmit, they should do so. Is that what you were thinking, Commissioner Covello?
In fairness.
Yeah, absolutely.
Fairness.
I agree with that. But I think it's fair to say that unless I hear otherwise from the commissioners, if we go forward with these changes, it is the Commission's intention to take up those applications unless we hear otherwise from those applicants.
What does that mean? Take them up today? Like
No. We can't take them up until the regulations become finalized.
I assume we could do it under the emergency basis once we SAPA.
That's correct. We can do them under an emergency basis, but they wouldn't. They're not going to be finalized today. No, they need to be. I'll let the staff explain, but.
If the Commission adopts the regulations to go under the SAPA process, it would adopt them as amended for the full SAPA process, but it can also adopt them on an emergency basis. The regs would become effective on an emergency basis once they are submitted for publication. So it's going to have to be a two-step process, that after this meeting today, the regulations will be submitted, and then they will become effective, and then after they become effective, the Commission can consider any pending applications or new applications that come in under those amended regulations.
I think there's another question here. Obviously, an administrative body cannot act as the legislature and change the standard. But I think we were told somewhere along the way that there's an infirmity in the standard as it exists now. I think the ACLU, has raised some questions.
Yes, the NYCLU, in its public comments that it submitted in part of the SAPA process that we just recently completed on the regulations, raised issues with the standard in the statute, which is substantial likelihood of harm. They made an argument that based on constitutional case law in a slightly different context, they argued that the appropriate standard is reasonable likelihood of harm. And based on those comments and other comments, this was presented to the Commission earlier this year, and the Commission adopted that standard of reasonable likelihood. And so that's why we are where we are today, which is that the Commission, I think, is suggesting that it reconsider that decision and return to the statutory standard of substantial likelihood of harm.
And I think they also opined that they might consider a lawsuit.
Certainly, I think any matters relating to litigation and litigation strategy and how the Commission wants to address those, we should consider in the executive session. That's consistent with our meeting guidelines and that the Commission adopted. So to the extent that you want me to address any potential legal action and what might happen, I prefer that we do it in that session.
Having said that, though, I think Commissioner Covello, though, identified the precise legal issue, and I think Commissioner Renzi did as well. I mean, they echoed what I said at the outset, which is there is a question, on the one hand, about whether we have the authority to depart from the statute in framing the regulation here. And if the legislature, in its judgment, and the executive in framing this law, considered what the legal standard is, then we're duty-bound to follow that. And obviously, the regulated community, to the extent that we take action that affects them, like any potential litigant, is free to file whatever litigation they feel they need to. I don't know, Commissioner Covello and Commissioner Renzi, if that captures what you were saying.
Absolutely. We should comply with the statutory language.
I don't think we have a choice.
If there's a challenge, then so be it.
Okay. So I'm happy to take these issues as they come, as individual motions, or do we want to take them collectively?
Well, the first question, I guess, is if we're talking about language, we need actual language, I think, to look at and discuss before we can adopt that, don't we?
Well, I think we have that language. I mean, I think we have 938.8, we strike confidentiality. We have language which is, well, not in the draft. If you look at 938.4, if you look at the third line of
Two different issues.
We're talking two different issues. Let's just stay with 938.8. I think what we need to do is put in the statute that it's all going to be released with the exceptions, as opposed to everything is confidential. I think we need that as the standard in the regulations.
Why don't you, Monica or Rob, why don't you explain, how this particular proposed amendment is anticipated to work as it relates to George's point about confidentiality?
Well, I'll probably be reiterating points that were made already, but the idea in deleting wholesale the confidentiality provision was that the groups would then, client filers who are seeking an exemption would then tailor their submissions knowing that the materials would be made confidential. We've had a small sample size. Arguably, it's a very small sample size of applicants. But based on what we've seen to date, again, acknowledging that it's a small sample size, that would not appear to be a significant impediment or problem for any of the client filers.
Is it anticipated that people are going to send us redacted and not give us the full information? I'm looking for, and then we would make the decisions. You're thinking that they're going to send us things, but it's not going to be everything. It's going to be something looking like the CIA sends out?
Well, quite honestly, not something that looks like the CIA would redact, or NSA, or whatever government body you want to choose. That the client filers would in fact take the redactions upon themselves. If the commission feels that there's too much information redacted, we could always go back to the client filers and say, based on the redactions here, we can't really make sense of the application. But in many instances, simply redacting the name and some identifying information, I think would give, in most instances, would give the commission enough information to assess the application.
I'd much prefer to see a regulation that basically says, you give us everything, we're going to take out anything that constitutes an unwarranted invasion of personal privacy. So one of these applications we got, as I recall, people had sent in letters and they had their home addresses on, and names and home addresses, we can take out. And then as I understand the legal standard relating to other issues in this area, it's information that we receive that's confidential that, if disclosed, would destroy the reason for them giving it to us. In other words, we shouldn't release it.
That's
Investigation. And that's a legal standard out there.
One concern with the procedure that you're discussing is that it sounds like it would be a two-step, two-meeting procedure. And that was one of the issues that we were trying to avoid. We wanted, and we thought about this, and of course it's ultimately the Commission's decision, but that the Commission should receive the same materials, for the most part, that are going to be made public. And if it comes in and the commission's going to consider what to redact, then we're going to have, that's going to be one meeting, the commission will have to make a decision on redaction, and then it'll be the next meeting where we can make the materials public and have the public discussion.
I'm not so sure that, I think you could have a two-meeting scenario the way Rob's describing it, because they send us something, gee, it's not enough, so send it back. But once the commission votes on it, okay, the fact that the commission says, staff, take out personal information, take out other information that should not be released to the public, and you just go from there.
And to return to the public.
Yeah, and then
without notifying the applicant
you could
what
you could
decision was made.
yeah. I mean that's the that in essence is that they're asking us to look at something, and in our judgment we're applying what we're looking at, and either as far as I'm concerned, staff can figure out what should get out there and what shouldn't.
So I think, again, that's a perfectly acceptable approach. The mindset, amongst some staff at least, was more in the sort of the litigation context, where parties routinely redact privileged information or trade secrets, and they're the ones that make the decision as to what information, in their view, should be kept from the public.
But
So
then-
that was the general mindset.
Then the judge is given a privilege log which has the unredacted names, and in camera reviews it and decides that it was
Sure,
appropriately
that's fine.
redacted.
If it's challenged, sure.
And that's why there are exceptions to, for example, in FOIL for trade secrets. Government gets it, but government won't disclose it.
I'm just letting you know where staff's sort of head was
Yeah,
when we
okay.
were developing this.
So is there a
propose
proposal
language?
on this then?
Well, we're going to need, from where I sit, we're going to need to replace what's been struck in the regulation with something says it's going to be disclosed, and then come up with the exceptions where it's not. In my mind, it's unwarranted invasion of personal privacy and things that we get that are given to us, and if disclosed, would defeat the purpose for it being confidential in the first instance.
So,
Which investigations may fall into, probably fall into that.
I mean, I think what you're suggesting could be accomplished if there's just some general language put into the provision. We don't necessarily have to get into the procedure in the regulation itself. That can be accomplished through a form that, in the instructions on our website, but that a standard language.
Standard, we need a staff.
So let me just say, the staff, I was given this morning by Rob a proposed replacement for 938.8. I can read the entire thing if you like, but I think the operative language, the commission may publicly disclose the fact that the client filer has submitted the application, and here is the exception. The commission may, in its discretion, grant a request from the client filer to keep confidential certain exemption-related information when such information is related to an ongoing investigation by a government body or when other extraordinary circumstances merit confidential treatment of the information. And I think George would want to add, including but not limited to, the unwarranted invasion of personal privacy. Does that satisfy you?
Yeah, I'm just worried about people who send things in based on our one experience.
So I think it would be, with George's addition, Ellen, are you prepared to offer that?
Sure.
Okay, so I think we need to have it read into the record.
Okay.
Do we have copies of it?
Yeah, we do. You want to just pass
Yes,
this around?
thank you.
All right, and I can read it. But you want to you first.
I only asked 5 times for copy.
Yeah, here.
Coming down.
Here.
Based on that change,
I'm just adding, including but not limited to. Some lawyer-like language.
would it make sense to have this sentence read, grant a request from the client filer to keep confidential certain exemption-related information when there are extraordinary circumstances merit confidential treatment of the information, including but not limited to an ongoing investigation by a governmental body or an unwarranted invasion of...
Yes.
Can I ask you?
That sounds good.
Okay. Go ahead, I have a question.
Okay, just the first sentence. Why did you use may as opposed to shall?
That was my point.
Right, right.
I think
Shall.
it should be the commission shall
Publicly.
publicly disclose, so that there is no
Yeah.
question
Right.
that this commission expects applicants to understand that these exemptions are going to be filed publicly and considered publicly, and if the narrow set of circumstances are presented and the commission feels that are embodied in this proposed regulation, if those circumstances are met in those narrow set of circumstances, then we have discretion to keep some portion of that application confidential and considered an executive session. I think that fits with the spirit of what we've been talking about today.
Mr. Chairman, you mentioned that we tilt towards full disclosure, but this exemption was included in the statute, and it is a competing interest because of the potential harm that could occur to contributors to various organizations. And I am concerned, we say here, or Ellen says, other extraordinary circumstances. I've spent most of my career, construing statutes, and what do we mean by extraordinary? And I would maybe suggest special instead of extraordinary. I'm not sure that's too much better, but it may give us slightly more leeway. I just don't know what
I mean, we're happy to have another jurist bring that perspective, because it's obviously important for those of us who are lawyers. We only, advocate, but it's good to have that perspective. I turn that question open to the commission and the members, because, I think we've had a pretty robust discussion about this, and I'd be curious to hear what the other commissioners' view on that change would be.
And, Mr. Chairman, this proposed language.
Is the comment by Judge Roth to include both special or other extraordinary circumstances, or
I
other
would
special,
just
or
use special.
both, or are you suggesting deletion of extraordinary and with the substitution?
I would substitute special for extraordinary. I like to give myself wiggle room.
Yeah.
Well, we're linking it back to 938.4 anyway, so
Right.
maybe we ought to use the language in 938.4. Substantial likelihood of harm. That's the standard. Or link it,
No, but I think the concern, Dave, was that in considering that language, is a number of folks have said, I think there's a fear that if you do that, then perhaps the exception will swallow the rule. And again, if the commission's sentiment is to tilt, in this balancing toward full disclosure, we don't want to be equivocal in what we say. Commissioner Levine?
It appears to me in any event that is the phrase circumstances merit confidential treatment. So if you just excise the word extraordinary and substitute the word particular from the word circumstances,
That's good.
Yeah.
That's yours.
E.F. Hutton has spoken.
That's good.
Ellen, you're okay with that?
I'm fine. I don't know
Okay.
who's making the motion.
All right.
Well, should I read the language?
I'm making the motion. It's fine.
How do I vote to vote aye?
His Honor was talking.
I think Judge Diori had a
I
comment
have a
earlier.
question. And the question is, George, I want you to be completely satisfied that receiving all the information, but extending to the applicant the opportunity to request that certain information be kept confidential fits with what your original remarks.
My thinking is they can request it, but they have to recognize that, this is not necessarily a big give and take process.
Yeah, that's fine. And if that's so, then I think that could work as a matter of process. I think we don't want to have the ultimate burden of deciding what is or is not a substantial likelihood of harm if we can avoid that. And if somebody...
I'm not proposing a substantial likelihood of harm, Your Honor. That was...
Well, that's the
two
second,
separate issues.
that's the other amendment, right.
That's the other
That's
amendment.
two
For this, just focusing.
Particular is good.
So just so that everyone is clear, there's two separate amendments on the table. One is to delete 938.8 and replace it with language that makes it clear that the commission's presumption is that the material will be made public, but allow the commission discretion on request to consider keeping some portion confidential if the circumstances merit it. And the other amendment, as I understand it, is to change the standard for considering the entire application for an exemption to go back to the statutory language, which is substantial likelihood of harm. So if this is going to be a rare circumstance where someone's going to actually ask for confidential treatment, but if someone asks for confidential treatment, that would be the first consideration of the commission, and then the commission in the public session would discuss the merits of the application, keeping that portion confidential, using the standard of substantial likelihood of harm.
Well, may I summarize what you just said?
Are you suggesting she was?
Summary going to be cogent, or is what she just said cogent?
I'm not sure I will be. The way this would work, the high concept, as they say in Hollywood, is that the entity would file all the information, including the donors and the addresses, and we would have that information. Then, based upon certain particular circumstances where we deem it appropriate to give it confidential treatment, then we would redact it and not divulge it to the public. The question, though, of granting the exemption, question in chief, the standard would be changed to substantial.
Yeah.
Do I understand that?
I'm not sure about the
Yeah.
first part that you described with respect, we might be on the same page, but we're talking about just the source of funding application.
Yes.
And so it would just be the information that they provide, their evidence of substantial likelihood of harm that would be before the commission. So it may have information about donors. It may have other information because there are different factors that, under the regulations, that someone can try and establish in order to show substantial likelihood of harm. So it might be any type of evidence that they want to submit in support of their application.
Yes. This is an important point you're making. The hobby horse I've been riding in the past few meetings is that if we grant the exemption, we should have the donor list, and we hold it in camera.
You're talking about we should have the actual sources of funding.
Yes.
Different
Yes.
than this, but it's a third issue.
That's a third separate
Yes,
issue.
okay.
Yeah, but the only thing I'm not sure as to what you said, Carrie, is are we doing the redacting, or is the applicant sending us an application in addition to the fully disclosed one that's a proposed redacted, and we might adopt that? Or are we going to be doing the redacting?
Well, with respect to both the application and any information, depending on how we proceed here, that we will demand as a condition of exemption, I could put it that way, we would do the redacting, not the applicant. But I will reiterate, and I recognize I'm being a little tedious about this, and I appreciate everyone's indulgence. If we grant an exemption, we should have the list of the donors and the addresses.
But it should be a continuing list, correct?
Yes.
In a filing, but just separate and apart that
Right.
doesn't get disclosed on
Yes.
the website.
Right.
Otherwise, we're not credible. Just charging.
Gary, I don't disagree with that at all. I think that that's going to require language to be added to this.
No, yes, it's Monica well stated.
Certainly, if you read this, and I do like it, that the applicant has the opportunity to request confidentiality of whatever it is.
Sure.
One interest it may be in. And if in the process they are advised in advance that request must come from them.
Yes.
What we do with what we get happens to be our business.
just don't everyone understands. I'm not sure.
Do you want to add it to this, or do you want to do
I
it
just-
separately?
I just want to make sure that we're understanding. I think that these are three distinct issues.
Let me just paraphrase before Monica, because there's no doubt that I think Commissioner Levine, what you're suggesting is consistent with the spirit that we're hearing today, which is disclosure in favor of, confidential. Disclosure is the hallmark of what the agency is about. Having said that, with respect to your proposal, there are some issues we probably need to think through and talk through now. Monica's going to, I think, talk us through them.
Right. So just so everyone, as I understand it, the issue that Commissioner Levine is raising is not about the exemption application and the merits of the exemption application and what they submit in support of it. It's whether or not, notwithstanding if the Commission grants the exemption, the filers should disclose to the Commission their sources of funding. So we're basically changing the nature of the exemption. That's what Commissioner Levine is discussing. So it would be, in some ways, almost a partial exemption. We were basically, what I understand the proposal to be is, they would have to make the disclosure to JCO, but that the information would not become part of their public filing if the exemption is granted. And so I just would like to draw Commissioner's attention to the statutory language to think this through, since one of the issues on the table today is returning to statutory language on the overall standard. And that is that it's in two different provisions of the lobbying law, and I'll just do one because they're identical, but the language in the statute is that the disclosure shall not apply to, and then it continues and it identifies.
What provision are you looking at?
It's the statute. I don't know if everyone
we don't
has
have
the
it.
statute.
Okay.
You have an
That's
extra
fine.
book?
Go ahead.
Okay, so the section that I'm looking at is in, where am I in? 1-H, it's the bi-monthly report
What section, Monica?
of the lobbying law.
The lobbying law.
It's lobbying law,
Lobbying law.
section 1-H in my book, but I don't know they're all numbered the same. It's page 111. It's hard to find different sections. So it's, do you have page numbers? No. Okay, so it's, I can find it for you. It's page 1-H. G-H. Okay, so then it's,
What section?
so it's this section right here. So just so everyone, I don't know if everyone was able to find the relevant section, but the statute first creates what they call, what's this disclosure obligation. And it says that if you meet a certain threshold that you do, that you've spent $50,000 in lobbying in New York, and that 3% of your lobbying activity, of your expenses are for lobbying in New York, then you need to disclose sources of funding over $5,000. And then the statute continues that in two different places, that this disclosure shall not require disclosure of the sources of funding whose disclosure and the determination of the Commission upon a review of relevant facts presented by the reporting lobbyist may cause harm, threats. That's one. Okay, that's for an individual donor. And then if you continue to the next paragraph, it also says this disclosure shall not apply to. And this is where we are now. If you look at little 2, any corporation registered. Basically, any 501c4 whose primary activities concern any activity of public concern determined by the Commission to create a substantial likelihood that the application of this disclosure requirement would lead to harm, threats, harassment, or reprisals to a source of funding, and continues there. So what's at issue is the meaning of this disclosure shall not apply to, or this disclosure shall not require disclosure of the sources of funding.
So then we cannot implement Gary's suggestion by way of the regulation.
Well,
No?
I'm not knowledgeable enough to it does seem to me that we ought to consider the juxtaposition of disclosure with a threat of harm means what is implied by disclosure is public disclosure. No one is going to assume that if the members of the commission or the commission staff have the information, that there is thereby engendered a threat to the applicant or its members.
Because it depends on the commission.
Aren't we again running into the problem, Monica, of rewriting
for the
One second.
wait.
I think, from what I'm hearing, we're in danger of emasculating that provision that provides for the exemption, and it was
It
included.
says the disclosure shall not apply to.
Right. We can't do it.
Well, I think Gary's right. Revealing to us doesn't mean disclosure.
Yeah, how many people
Obviously
get to see
absurd
it?
to think that if we have
Where's the definition?
that a threat is thereby engendered.
One
That
C.
can't be. And we
We don't-
know that we're not subject to the Freedom of Information law, so we can hold in camera any information or data we deem appropriate.
Well, I think we have,
But if you want to table it for
I wanna
further
table that,
analysis, I'm
yeah.
not going to make my vote on the rest of this contingent
Right,
on that.
I do.
But I appreciate you letting us say my piece.
look, I can't agree with you anymore, as I've said several times today, that, disclosure, and I am sensitive, obviously, I think we all are, to the comment that Judge Roth made, which is that the statute obviously has an exemption, and the framers of the legislation had a particular set of circumstances in mind. That having been said, we've been talking about balancing, so I think I think it is something that is serious, and that it's something that warrants further discussion, particularly because of the legal issues. So I think, and I appreciate the customary gracefulness with which you've made your last comment to facilitate, I think, moving the meeting forward.
It's
So
all a graceful retreat.
yes,
Well, I got there.
it's a graceful retreat. So just to summarize where we are, so I think we have in front of us a draft, 932, amend 938.8 with certain changes. The third word, may, shall be changed to shall. And then I'll ask Monica to read it into the record with respect to the other aspects. And then I think we need a motion on this. And the other issue is whether and I don't see any reason why, if there's consensus, and it sounds like there is, to make the other change we've been talking about, which is to amend 938.4, strike reasonable certainty and substitute substantial likelihood. We need a motion on that in a second. But again, just for the sake of making sure we have a good, clean record, and that everybody at the table and those who are watching and present in the room understand exactly what it is that we're considering.
I
Go ahead.
have
Yes, John.
no problem, Mr. Chairman, making that motion, but does that mean that you're moving toward continuing the process even though we don't have Gary's provision on board?
Yes, I think as I understood, obviously Gary, I thought what I understood Gary to be saying is that we would consider that issue separately and at a later date after we've had an opportunity, I think, to have more input and analysis on the meaning of the statute, and particularly with the phrase disclosure and what that means. Is that a
Exactly,
fair
yeah.
summary of where we are?
Yes, yes.
One motion. Seymour.
Mr. Chairman, I had a question on the word governmental, and what bodies does that include? That's in line 8.
In,
In the draft language, right now, it says related to an ongoing investigation by a governmental body.
Well, if we're tabling the whole thing, we can then
Not tabling.
go over every...
No.
no, I don't
we're
think,
gonna
I
vote
don't
on
think
this.
we're tabling it, Judge. I think that,
The exact language, right? We're not tabling the idea, but...
No, we're going to
No.
vote on this.
There's,
I think just to be clear, we are going to vote on amending 938.8 on confidentiality, consistent with what the staff has presented with some of the changes we've talked about. We are also going to, upon a motion, vote to whether or not to change the standard for the exemption from reasonable certainty to
Why don't we
60.
do that first, since we're all clear on that, and then come back to this?
That's what we all doing.
Commissioner Yarashevsky?
Okay, if it'll help, I will move that we change 938.4 to omit reasonable probability and put in substantial likelihood.
Okay. Is there a second?
Second.
All in favor? Aye. Aye. Any opposed? Seeing none, that motion is carried. Okay. And now we can turn to 938.
I just, do you want to, on an emergency basis, do you want to do that separately as a third motion? About all these changes?
Well, let's amend,
Let's get it all.
let's get it all done right now. So I'll make that motion. Joe, you want to make the motion?
I'll make it on 938.8 that we adopt the language, we strike what's there, adopt the language that we discussed and circulated.
Okay, but I think wait,
938.
before we get to 938, I think we're waiting for a motion that the change to 938.4 be adopted on an emergency basis.
So moved.
Second?
Second.
All in favor? Aye. Any opposed? Seeing none, the motion is carried
Okay.
unanimously. All right, now let's turn to 938.8.
And once you've made your motion, I'll read the proposed language.
I made the motion.
No,
Joe made the motion.
I'll second it.
but can we
We want to read the
hear-
language
hear what
first.
the language is?
Of course.
Come on.
Was there a
Guys need to get on the same page.
Wait, so
The
there's
two
no...
of you need to get on the same page
Okay.
We
here.
haven't even met each other.
You're not sitting next to each other. That's the problem.
I'll read the language, and there's no second yet? Is that...
There
The
is.
Commission shall publicly disclose the fact that a client filer has submitted one or more applications for an exemption, or that one or more of a client filer's request for an exemption has been granted or denied. Information submitted in connection with an application for an exemption or in support of an appeal from a denial of an exemption shall be publicly available. Notwithstanding the foregoing, Executive Law, Section 9419A5, Legislative Law, Section 1S, and any corresponding regulations, the Commission may, in its discretion, grant a request from the client filer to keep confidential certain exemption-related information when particular circumstances merit confidential treatment of the information, including but not limited to an ongoing investigation by a governmental body or unwarranted invasion of privacy.
Not and.
That's good.
And. Or an, A-N.
Or an,
Oh,
an.
The
Okay.
Commission may, nevertheless, disclose such information, there's a 1, to the judicial hearing officer assigned to the appeal, 2, to a court in a judicial review, or 3, in response to any subpoena or court order.
You make the motion.
Second.
Yes.
All in favor?
Aye.
Aye.
Any opposed? Not seeing none, the motion's carried unanimously. Do we have a motion to have that regulation considered on an emergency basis?
So moved.
Second?
Second.
All in favor?
Aye.
Any opposed? Seeing none, the motion is carried unanimously. Okay. Okay.
Now, there certainly is a way to belabor this conversation, which is to say, the process by which we're going to do this. And I don't know that we want to take this up now or later. Maybe we want to table it.
That's going to be...
But there are a number of questions. So should we raise it later?
I think what you're talking about is, at this point, notwithstanding, our desire to, have these discussions publicly. Right now, the state of the law is that any discussion of the current exemptions, until these regulations become
I'm not talking about current exemptions. I'm talking about, well, I think we should table it. I think we should have a discussion maybe next time about the process by which we're going to implement this.
I think we ought to ask staff to prepare.
Yeah, I was gonna say perhaps our staff.
I was just going to suggest that
Okay.
as soon as
Consideration
Good.
and determination.
Yeah.
Okay.
And we might do that by committee, we might do it by committee of the whole, however you decide to.
Could we also ask staff to do an analysis as to Gary's point,
Yes.
the legality of that, and
Yeah, this
their
is,
thoughts on that?
Chair, this is not a new issue, Gary's point.
No, well, obviously, we have to be circumspect. Yes,
Yes, but
this is
it's,
it's an important issue. It's one that deserves our full attention. I believe the staff, should and will analyze this for us, this issue. And I think that Judge DiOrio and Ellen and Judge Roth's suggestion that, we give some thought to, if you would, implementation before the next meeting is a good idea. And I think, let me give some thought about, whether or not we want a little committee on that or not. If you are interested in helping out on that, let me know, obviously. We can put something together.
I just want to make this suggestion. I know staff is really busy. It would be very helpful to get a memo like that with at least a week before a meeting to consider it, because it's really difficult when we get matters just the day before or two days before.
I'm confident that the staff will be able to do that on
Okay,
this,
great.
this issue. Okay. Unless there's any other further comment on item 4 under regulations, I don't have any other new or other business, and seeing none from anybody else. Is there a motion for us to enter into executive session?
So moved.
Second. All in favor? Aye. Noes? Seeing none. Thank you very much. That concludes this portion of our public session of our meeting. We're going to go into executive session. So,
Let's get ahead of it.
we're now back in the public session. During our executive session, we considered several investigative matters, including authorizing communications and closing certain investigative matters, and we granted a request pursuant to Section 8B. That concludes our meeting, and I need a motion, unless there's any other business, to adjourn the meeting.
So moved.
Second? Second. All in favor, say aye. Any opposed? Seeing none, the motion's granted. Thank you very much.
Thank you
The meeting's
very much.
concluded.